how many of you were able to complete the paper? I don't know if you guys see. That's where I tell you, if possible, try to come in home. I'm 100% sure you would have written for 2.5 hours. Yes or no? Try to have a clock. If you had written it here, if anyone has written after say exact 100 minutes, they would have come and they would have taken your paper, or they would have given you some 5 minutes, 10 minutes grace. Agreed? Huh? For people who had come here. So if you're doing that, continue to do that. Yes, as I told you, in law there is two challenges. One is completing. The completion of paper. What is the biggest challenge? You will understand it while you're in exam only, if you do not write it here. Again I'm telling you, but you will understand it when you are there. For people who are trying to take it up with the timelines, continue doing that. Yeah, it will definitely help you to go towards the 100 mark, whatever, at least 90, 95. Now today in the 5 questions, how many questions were you guys able to write? All 5 you were able to write? Comfortable? Yes? Okay. So by end of the week, by the time you start your next week, you should be able to write 6 questions in a day. Yes? Because today what happened? There was a 3-mark question, there was a 4-mark question. So it was not 5 into 5. So 3 was also there. There was a 4-mark question also. If I take an average, that means it was around 19 marks. So technically it's not 25 marks. Yes? All of you? Okay. Okay, next question. Okay. Mr. Lal, a well-known builder, entered into a contract with Mr. Kumar, a property developer, to construct a large shopping mall in Jaipur for a total consideration of 10 crores to be completed within 18 months. After the work began, both parties mutually decided to alter the nature of their agreement. By mutual consent, a new contract was substituted, under which Mr. Lal would, instead of constructing a 5-star luxury hotel on the same land for an increased price of 12 crore. So instead of large shopping mall, now they want to construct a 5-star luxury hotel. Okay. This new agreement expressly cancelled the earlier mall contract. However, 6 months after the new agreement was executed, the state government, under its urban development policy, passed the law prohibiting the construction of hotels in that particular commercial zone, though the construction of shopping mall was still permitted. Due to this prohibition, Mr. Lal stopped the construction work and informed Mr. Kumar that the contract had become impossible to perform. Mr. Kumar, however, filed a suit against Mr. Lal for breach of new contract, demanding damages on ground that Mr. Lal had failed to perform his obligation. Decide under the provision of Indian Contract Act whether Mr. Lal is liable for breach of contract or whether the contract has become void due to impossibility. First thing, people, you should be very thankful for this question. This question could be made very, very, very tricky. They made it easy for you. Very, very easy for you. For example, this last line could have been literally avoided, not required. It's an help that they made you. One more thing, one more help. This is an help they made you. This and all, if you give me as an exam or a question setter, I would have not added all these details at all. This is something which you guys have to figure out. Now, if you ask me, there is no question only here. Everything they have only explained. But yes, nonetheless, tell me what is the answer. I hope you guys understood the question. A and B entered into a contract to construct one shopping mall. After 18 months, they realized that no, shopping mall is not something that would work out for us. They want to replace this agreement with a new contract. That is, they want to build a 5-star hotel. After they decided and after they replaced an agreement, that state government passed a law saying that you cannot construct this 5-star hotel here. Now, because of this, what did the person decide? The person decided, let us cancel the construction. He informed the person, I cannot construct this particular thing anymore because the law has been made, impossibility. They said you cannot construct it anymore. The other party is now filing a case on him, saying that you are doing a breach of contract. Now they're asking you, what is the compensation? Is it a breach of contract? No. What and all are the provisions? What and all you will write? Supervening impossibility. Okay, very good. You have to write. They're asking you breach of contract. Now, technically, there are two contracts here. One is a mall. Second one is 5-star hotel. What if they did not tell for which he is filing a breach of contract? Is it towards the mall or is it towards the hotel? It is my duty to write both. So, in this question, provision will be huge. You have to write what is novation. Whenever the parties under section 62, under a mutual agreement, when the old contract is replaced by a new contract, the old contract need not be performed and it is discharged by law. And because of that, you cannot claim any breach of contract or damages for the old contract. That is for the construction of mall. So that is done. Now coming to the 5-star hotel, due to change in section 56, correct? Due to change in law, what happened? It became subsequent impossibility and hence it became a void contract. Yes, sir. Now it is impossibility of performance. Now because of that, what happens? You cannot exercise it. It is discharged by law. Even the 5-star hotel also, you cannot perform. So whether he'll be, can he exercise? Answer is no. I don't know who, Mr. Lala, or I don't know, Kumar, however, filed, I don't know. Okay, Kumar filed on Lal. So Lal is right. Kumar cannot, recover any damages from Mr. Lal, as one is discharge due to mutual agreement. Next one is discharge due to impossibility of performance, subsequent impossibility or supervening impossibility, which makes the contract as void. Hello? Yes? Done. See the answer, how big it is. You have to write all the provisions here. Novation, subsequent impossibility, and then the conclusion. Hello? Okay. Albert obtained 2 loans of 3 lakh and 4 lakh respectively from a reputed bank. Out of these, loan of 3 lakh was guaranteed by Robert. So 3 lakh, 4 lakh was taken, it seems. 3 lakh was guaranteed by Robert. Albert sent 2 lakh to bank but did not intimate as to how it is to be appropriated. He repaid 2 lakh to the bank. Albert repaid 2 lakh to the bank. Robert is a surety. I hope you guys understood. The bank appropriated the whole of 2 lakh to the 4 lakh amount. Robert objected on the decision of the bank. He argued with bank that repayment amount should be first adjusted to the guaranteed loan. State with reasons whether the bank was correct in its decision under the Indian Contract Act 1872. Understood the question? What happened? The person has taken 2 loans. One is 3 lakh, one is 4 lakh. The 3 lakh loan has a guarantee, which is given by Robert. It has taken as 2 different contracts. Now Albert repaid the loan, people. How much he has repaid? 2 lakh rupees. Now what did the bank do? Albert did not say to which loan I am repaying. The bank has taken the loan towards the transaction which did not have guarantee. So it has taken towards the 4 lakh. The guarantee, whoever is the surety, he has raised an objection. How can the bank do that? It is arbitrary. They cannot take the entire 2 lakh towards the loan which does not have guarantee. Even I should also get benefited. Now they are asking you whether state with reasons whether the bank was correct in its decision. Is the bank correct? You guys are reading the question first time here, Ada. You didn't even read it. Illa, yaka? Didn't write the test work. You can take up at least questions and see, no? Nothing. Okay, tell me at least what it is. What is the Shiva? What is the provision? Appropriation of payment. So is the bank right in what they did? Bank is right in what they did. Remember people, whatever the bank did, the bank is right, sir, because the question, most of the people will think the case in the form, in the scenario of surety and guarantee. The answer is not in that. The answer is in appropriation of payment. Surety is just a deception, that's all. So appropriation of payment rule is simple. If the debtor is silent, if the circumstance is silent, then who will have the right? The creditor's choice. So the bank has a right to take it towards 3 lakh or 4 lakh. It is its choice. So the bank took it towards 4. So whether the action of bank is right, the answer is yes. The bank's choice is right. It's unquestionable. Understood? Appropriation of payment. That's the answer. Section 60. 59 is debtor or circumstance. 60 is the creditor. 61 is the payment. Meaning first FIFO when both are silent. C.A. Sarthak Jain had decided to get interior work for his new office. For this purpose, he entered into a contract with Measures. I don't know if you guys are realizing, are you getting the quality of questions? You just imagine, these are RTPs, MTPs. I have not even touched the past papers yet. So RTP only, this plus 40% is the quality in your main exam. Yes, sir. Hello? For this purpose, he entered into a contract with Measures Sharif Fine Interiors. It was agreed that Measures Sharif Fine Interiors will complete the interior work by 31st Jan 2025. On 2025, a CS Arthik Jain observed that only 20 to 30% work is completed. He decided to cancel the contract with Measures Sharif Fine Interiors. Measures Sharif Fine Interiors filed the suit against CA Sarthak Jain for recovery of the cost which he incurred on the interior work. CA Sarthak Jain argued that Measure Sharif and Interiors did not complete the work within the time as per the contract, and further the work done till 31st 25 by Interiors was of no use to him as he has to appoint new interior designer. Explain whether CA Sarthak Jain is liable to pay the cost of the work done by Sharif and Interiors under the provisions of Indian Contract Act 1872. What is the answer? Void contract? Why? What is a provision? I hope by now you and me both understand when I say provision. Now in the previous case, provision means appropriation of payment. You need to tell me what is a provision here. On what grounds you are telling that whether the interior company can recover the cost or not recover the cost. Under what provision? If these two words are wrong, your entire answer is wrong. I will not even read to whatever is the your biodata you have written there. What is a provision? What is a provision?
Compensation after the new one has been appointed, remaining amount has been.
So can he recover money or not?
So he can recover after deducting the reasonable prices used for the.
So the question is, I have invested 20-30%. Can I recover money for that or not is a question. Can the interior company recover the 20-30% or not? That is what they are asking you. CA Sarthak Line is he liable to pay the cost of the work done? Can they? What is the provision? Reciprocal promise. Right? What answer do you have in reciprocal promise? No, answer is wrong. See, I thought at least you would say the wrong answer in a right way. That also is wrong only. 90% people will write it as quantum merit, as much as performed. That means what? Hey, you appointed me to do the entire interior work. I have done 30% it seems. And the person cancelled the contract. 30% I have done. Can I recover that money or not? Yes or no? Can I recover or not? So people generally write it quantum merit, but it is wrong. Why? Here again they have given one more hint. What is that? See, first of all, two provisions. One, people will think quantum merit. It's not quantum merit. Now, what is the provision under which I will write it? People, the party can cancel the contract, rescind the contract when the contract is not performed as on the agreed time. So you have clearly said that the agreed time is what? 31st January 2025. The contract is not performed as on 31st Jan 2025. When the contract is not performed as on the agreed time, the contract may be voidable at the option of the party. Now it is my choice. Now I can put an end to the contract because it is not performed on the given time. So because of that, I will treat the contract as void. It is technically voidable. I will put an end to the contract. So I am rescinding the contract. Now the question is, whenever it's a voidable contract, what is the thing? Whatever benefit I have received, I have to return it back. I've taken some benefit. I have to return it back. Now the question is, have I taken any benefit? For that, they are only helping you. I don't know why they are helping you so much. Measure Sharif and okay, see here. CA Sarthak Jain argued that measures Sharif and Interiors did not complete the work within the time. So within the time, so I can breach of contract when the it is not agree. I mean it is not delivered as per the agreed time. Yes, sir. So you can resign the contract. Okay. As per the contract, and further the work done till 31st December by Measure Shali is of no use to him. So what benefit have I received? As he has to appoint a new interior designer to re-get everything. So have I received any benefit? No, that is my second part of the done. Second part of the answer. What is that? In a voidable contract, a person who treats the contract as invalid will have to return whatever is the benefit received. However, in the given case, Mr. Sarthak Jain has not received any benefit. As the 20 to 30% thing delivered is of no use, and he has to get another interior designer to work the entire thing yet again. So the answer will be what, people? The Sharifai Interiors will be unsuccessful in recovering even the cost that they have spent, 20-30% also they cannot recover. Understood? Hello? Pakka? Yes? When will it become the case of quantum merit? Quantum merit will come in the scenario 100% of the work is done. I mean 100% of the work was given, but the person has only completed 30%. Completed 30%. Now they would have given in the question the rest of the work should be redone by another person. Contract can be divisible. So in that case, what do? I have to pay for at least, now imagine that we wanted the interior work for this entire floor, but he has done it for 3 classrooms. Another 4 classrooms it is not touched. 3 is done. For that I have to pay. That is the case of quantum merit. They would have given work completed. 30% of the work completed.
So here the 20 to 30% work is completed is given.
That's what I'm saying. They would have said this is given no here. So if that is not given, then yes. That's where I'm saying 30% work completed, and the rest of it he had to get it done again from another interior designer. Here they are telling they have to get everything done from another person. So no, not possible. Understood? Not liable to pay the cost incurred. Did not provide. Because what is the answer? Any benefit received should be returned back. I have not received at all. Are you getting the point? That's why the words makes a difference. Clear? Rakesh, I think this is clear. Okay. Rohan of 17 years has purchased a mobile of 25,000 for his online classes from Mobile Sales Center on credit. On due date, he did not make the payment of mobile. Mobile Sales Center sued Rohan and his parents for the price of mobile. Rohan has 15,000 as his cash balance, but his father has enough money to pay the price of mobile. Examine the given situation and answer who will be liable to pay the price of mobile as per the provision of Indian Contract Act 1872. Who will be liable? Dad will be liable. Why? Minor case. The dad will be liable. Why will dad be liable? 100 times in the class I have told you, a minor can never bind his parent or guardian. That's the exact provision they want us to write. So you have stepped properly, very grandly, you have stepped on a landmine. So a minor can never bind a parent or a guardian. Here, even if the parent has money, parent is not liable.
So the amount which he has is
up to 15,000, whatever it's there, that is liable. Beyond that, people, minor will not be liable. That's the answer.
Because it is for the essential.
Yes, sir.
Necessities.
Now see what do they write. A minor is not capable of entering into a contract to the minor is what I mean, so cannot enter into office liability. Parents or guardians are also not liable for any contract entered by the minor. See this. However, a minor is liable for supply of necessaries. Now, someone asked a question, sir, how will we know it is necessaries or not? You asked me, remember? Now that's why they are helping you so much for online classes. Make sense, ah? Now it becomes necessity, ah? So now what I'll write the minor estate is liable for necessaries. Estate means what? Whatever minor has, that is liable for necessaries. How much does minor has? Minor has 15,000. So minor is liable up to the extent of 15,000. Parents are not liable. Clear? All of you? Rahul hired a car. Okay. Rahul hired a car for 15 days from Measures Kushwa Travels after 5 days. Rahul hired a car for 15 days from Measures Kushwa Travels. After 5 days, Measures Kushwa Travels demanded back his car from Rahul. He was also agreed to compensate for any loss suffered by Rahul due to such premature return of goods. But Rahul refused to return the car before the period of bailment, that is 15 days. Measures Kushwa Travels sued Rahul for recovery of car, referring to the provisions of Indian Contract Act whether Measures Kushwa Travels can recover car from Rahul before the time fixed for bailment or not. They can recover.
No, sir. It is a non-gratuitous bailment.
It's a non-gratuitous bailment. Very good, people. Hey, there are two types of bailment. One is gratuitous, one is for hire. Non-gratuitous. Gratuitous bailment alone can be what is that? Cancelled. You can ask for returning the goods anytime, only if it is a gratuitous bailment. When no consideration is involved, then compensation will come. You have taken, your friend has taken the vehicle from you. You're asking them to return it back within 5 days only, but you gave it for 30 days. They have spent money to service the vehicle. You have to pay for it. That's why they're confusing you by saying compensate. But however, in this case, it will not come. Why? Clearly, the second word itself is the answer. The car was hired. Whenever the bailment is for consideration, that means it's a non-gratuitous bailment. In such case, premature termination is not possible for any purpose other than inconsistent use. Now, in this case, it is not an inconsistent use. So, in the case, can they cancel the bailment? Answer is no. Provision is that can they recover? Answer is no. They cannot recover as it is a non-gratuitous or a bailment for hire. You can write it as anything. Understood, all of you? Yes. Next one. Ajay appoints Vijay to sell his electronic goods lying in his godown. He also agrees to give 10% commission on the sale price to Vijay. Afterwards, Ajay revokes Vijay's authority by sending the letter to Vijay. The letter was sent on 3rd March, which was received by Vijay on 7th March. On 5th March, Vijay sold the goods worth 1,20,000. He claimed commission from Ajay, but Ajay refused as he already revoked the agency before the sale of goods. Referring to the provisions of Indian Contract Act, whether Ajay was liable to pay commission to Vijay or not. What happened here? Ajay has appointed Vijay as his agent to sell the goods, and he will get 10% commission on whatever sales he makes. Later, people, Ajay has revoked Vijay's agency when he has written a letter on 3rd March that has reached to him on 7th March. Now, meanwhile, what happened on 5th March, Vijay has done a transaction worth 1,20,000. They're asking people whether Ajay was liable to pay commission to Vijay because he has done a transaction after he has revoked the agency. So, is Ajay liable to pay commission to Vijay? Is it required?
Yes, sir.
Yes. Why?
So because he came to know about it only on 7th March, but the transactions happened on 5th March before the communication was accepted by the Vijay.
Understood. So, provision goes effect of termination. When will the termination be effective? whenever it comes to the knowledge of the agent, for the agent, if at all they've asked the third party, whenever they knowledge of the third party, you remember, hello, in the given case, when does the agent comes to know about it? Agent comes to know about it on 7th. So that is when the agency is revoked. Whereas the transactions happened on 5th. So for whatever the transactions happened, yes, people, Ajay will be liable. And they have given you what is the amount, they have given you what is the percentage. Calculate and write also.
12,000.
So he is liable for 12,000 rupees and he has to compensate Mr. Vijay. Is this clear? All of you? There was a difference between bailment and pledge. Direct answer, I think you guys could have managed. Bailment is your generic transaction, pledge is always for security.